Assalamualaikum and hello everyone. My name is Zulkarnain bin Abdullah and I'm from Faculty of Law UKM. So today we are going to talk about a land law case, which is the name is KUCHAI Corp Sdn Berhad and KAMIS bin KARIM, which is this case is in regards of permit to remove rock materials. Moving to the facts of the case. The case is about land administrator who approved a plaintiff application to construct an access road from the said land. In the meantime, the defendant also get a permit by the same land administrator to remove rock materials under section 72 of the National Land Code. The permit was given without providing any qualifications or reservations. Then, plaintiff found out that the defendant had excavated the soil on the site of the approved access road. The plaintiff also contended that the defendant had carried out the excavation, although the notice of approved access road was given to him, and also the defendant also agreed not to dig at the site, but he still dig at the site. So the plaintiff now claimed for the defendant to fill up back the excavated area and compact it back. The plaintiff also claimed for damages. So, according to the evidence, it is found that defendants really had excavated on the area. However, there is a question arise because there is two parties in this case, which is the plaintiff and defendant being giving out separate benefit on the same land by the same land administrator. So, moving to the issue of this case. The issue is that whether a decision or order of any administrative authority such land administrator can be revoked or modified. The rules and application of this case. So, court refer to the case of Finance Berhad and Lim Yok Fu, 1982. It was said that once a land administrator had issued an order for saying respect of certain land, it was therefore functions officio. The second order will be null. In such circumstances, the land administrator in this case should not give the defendants a blanket permit, which is a permit without placing restraints or caveats upon the said permit. We should be excluding the defendant from excavating of the approved access road of the plaintiff. So, based on the authorities and the evidence, the court held that the defendant immediately fill up back the soil that the part already excavated of the access road, and also the court held that a declarations on area applicable to the permit to remove rock material given to the defendant should exclude the land which an access road is required to be constructed by the plaintiff. Okay, my commentary on this case is that I agree with the decision and reasonings of the courts in regards to the land administrator, which that the land administrator should not giving out a blanket permit to the defendants without putting any restraints or caveats on the permits, which supposedly excluded the defendant from excavating on the approved access road. So in here, I believe that there should be an inquiry or an inspections by the land administrator before giving out any permit. This is to avoid these kind of problems. So as we can see that in this case, the issue arises when the land administrator was overlooked at the fact that about the application of the access road and giving out the permit to defender without having a double check. So if it was the fault was not on the land administrator and it was on the defendant for action, the land administrator should put a restraint on the defendant not to excavate beyond the designated area. So it is important for the land administrator to inspect the status of the land before giving out permits, and should put on restraints to the defendant if the said land need a restraint. For example, in this case, restrain the defendants from excavating on another areas which is not supposedly in the designated area. Thank you.